morning, Bromer versus Wyman. Each party will have 15 minutes to present their argument. First appellant, you may reserve up to 5 minutes. How long would you like to reserve?
I'd like to reserve up to 5 minutes.
Okay. You'll note over there is a clock. If you're looking at that, please just look at the top one. When that gets to 5 minutes, that's the end of your time. I'll try to remind you there's about a minute left of your time otherwise. And then we'll still probably use that top circle for rebuttal. And I understand you folks know you need to divide in some capacity your time.
That's correct.
How have you decided that?
Well, 10 minutes and 5 minutes. 10 minutes for Huntington and 5 minutes.
I'll try to let you know again when you're about done with your first 10 minutes.
Okay.
Mr. Dugan, you going to run up and grab him, or if he's going over, what are we going to do?
Fair enough. I'll keep an eye on it.
Just so we know, okay. How are we going to put that? We'll go from there. Okay. Other than that, the argument is being recorded. When you present your argument, please introduce yourself when you come up to the podium. Please make sure you stay behind the podium because we visually record as well as audio record, and we'll lose you visually for sure, and maybe lose your audio as well. In this case, if you have any folks you view as victims, please use their initials rather than their full names in this case. Other than that, the parties have read your briefs and are ready to proceed whenever you are.
Good morning. May it please the court, I'm Rick Brunner from the law firm of Brunner, Quinn in Columbus, and we represent the three appellants in this matter: Philip Bromer, the estate of Joanne Bromer, and the Louis Bromer and Joanne Bromer Revocable Living Trust, 2003. In 2018, young Philip Bromer, who was just out of high school, lost his mother. Within a few months, he lost both of his sisters, dying 6 days apart. By 2021, he found himself outside of his parents' house, and all the assets that were supposed to be in his parents' trust and the vehicles that were supposed to pass to him, including the vehicle that he had paid for and driven since high school, were all under the control of his brother-in-law, Dean Wyman. My client filed suit pro se. After a few months, and when the other side hired counsel, he realized the error of his ways and retained our law firm. We filed an amended answer. Amended complaint, excuse me. We filed an amended complaint and started taking discovery, and what we found out is that there were assets that needed the joining of the estate and the parents' trust as plaintiffs, so we filed a second amended complaint joining them. In the course of that, originally in Huntington Bank was joined because they have a lien on the property, and it's a line of credit in the decedent's name, and even though the decedent at this point had been dead for 3 years, they were still carrying the line of credit in the decedent's name and sending the decedent monthly statements. That was the original reason that the Huntington was joined as a party. When the estate became a party, became aware that there was a bank account. And the bank account was a joint account with my client, Mr. Bromer's late sister, Cindy Wyman, who was one of the sisters who died. And we found out that the account was a joint account, but there was money being taken out after the date of the decedent. Again, the Huntington Bank to this day has never, even though they acknowledge they've gotten notices of her death and death certificates, has never changed anything over to the estate of Joanne Bromer. Still continue as if Joanne Bromer was alive and making payments on the line of credit, and if Joanne Bromer was still alive and taking money out of the account. So on behalf of the estate, we thought need to file a first amended complaint for the complaint to bring the account in. Prior to filing that account, we had sought discovery from the Huntington Bank and asked them to produce all records regarding bank accounts in the name of the decedent. They objected to that discovery request and said it wasn't relevant to the litigation. We filed a motion to compel. After we were granted leave to file the first amended complaint for the estate, the Huntington Bank moved to strike it, saying it didn't think we had approval of the court yet to file it. The second part of their motion was an alternative motion for summary judgment, saying this was a joint account, therefore it all went to the deceased sister or her estate. They weren't a party, and therefore the court must dismiss the claims regarding the bank account. The the magistrate properly ruled that, yeah, I did give them leave to file the first amendment complaint for the estate, so your motion to strike is overruled. But then the court went on to grant the motion for summary judgment. The issue that we had with that, and we opposed it, is Huntington Bank offered no evidentiary materials. Civil Rule 56C says what we need, the pleadings, the discovery in the proceedings, the testimony, or affidavits. Huntington Bank presented none of those things in support of its alternative motion for summary judgment. We pointed that out to the court. We pointed out to the court we had a motion to compel them to produce documents regarding the account, which they had objected to. The court didn't rule on that. Instead, what ended up happening is the trial court adopted the magistrate's decision, even though, as we pointed out, the law regarding accounts has been really clear in Ohio. We all acknowledge this was the joint account. The problem is, there's no survivorship language. There's nothing in the record that showed that this had a right of survivorship. And this has got, since 1926, the Ohio Supreme Court has made it clear that just because there's a joint account doesn't mean there's a survivorship account. There has to be survivorship intent in the contract or specifically expressed.
Counsel, let me just stop you. In regard to the summary judgment motion, your argument is that they didn't submit any evidence.
Right.
Okay. But you just did indicate that the parties had agreed that this was a joint account. Nobody's arguing over that.
Well, in response to, they hadn't answered our complaint yet, because they filed a motion to strike. But we had put in our complaint that it was a joint account, but it was not a survivorship account.
Well, the reason I'm asking you that is, I understand that there was nothing to prove that it was a survivorship, but wouldn't that be then just an issue of law? Because you're saying the law is clear that it has to be survivorship.
Correct.
And if the law is clear, then they lose. If the law is the opposite, it doesn't matter whether they presented evidence or not, does it? Because the matter was just an issue of
Correct,
law.
correct.
Okay, all right.
Absolutely.
Okay.
I think the court came out wrong on the law, yes, because I cited these Supreme Court cases that say just because there is, there is a joint account doesn't mean there's survivorship unless it's expressly expressed in the contractual arrangement setting up the account. We don't have that. It's never been part of the record, but there is nothing that shows that there was an intent to create a survivorship account when the account was set up. And I cited the cases which appear at page 15 of our brief. I don't run through sites just to run through for the court, but there's several Supreme Court cases on point. Now, the appellee, the Huntington, tried this in the 5th District and argued, well, if it's not clear, then the default is their survivorship. Now, the 5th District rejected that argument. The 5th District said no, and it has to, as the Supreme Court said, it has to be expressed. It's not a default situation. I could not find any case where this court has ruled on that particular issue that it's not a default situation. All I can offer you is what the 5th District did in a similar case where, and that was on a motion to dismiss. The court ruled that no, it's not a default situation. The Supreme Court has made it clear you have to have the language.
What about the argument that there's a deposition attached? Are you arguing that there wasn't appropriate 53 evidence attached to summary judgment?
The deposition was a deposition I took. After the motions were submitted, but before the court ruled. And
That was made part of the record?
yeah, that was made part of the record. And where it really became important was I was able to point to it on the objections that I filed with the trial court. And in that deposition, the Huntington Bank admitted it did not have the documents creating the account. It could not locate them. And there was no indication that that it was survivorship in any of the language of the documents that they had. I used that deposition in support of my objections. It was not before the magistrate. It was in the record, but it was not argued because our motions and so forth had been there, and the memorandum contrary reply had been filed sometime before. That's what. But that deposition in time for the objections clearly made clear that they didn't have it. They didn't file it. They didn't show anything in support of that. So it's pretty clear that with regard to the Huntington Bank, they did support their motion. We don't argue that we attached a copy of the documents to the complaint, and it shows it's a joint account, but there's no indication of survivorship. And based on that, there was another problem. We also pointed out that the court shouldn't have ruled without giving us a motion to compel them to overruling their objection that the account information was not relevant. That was another thing we raised in our objections. And then there's a second thing that happened, and the trial court kind of made light of it, but they filed a reply in support of their motion for summary judgment 2 days late, and I didn't make noise about it. I did not. But when I did make noise is that they filed a second reply. This was in the August, September area. They filed a second reply in support of their motion in November. And
About a minute left, counsel.
okay, so I didn't. So the other thing, I'm just going to switch to my other assignment there. With regard to the other one, the only one I'm going to raise is the issue of failing to grant us time to file objections to the magistrate report on the second part of the case. We argued the case in October. It was submitted to the court. The court came out with the magistrate came out with a decision on March 26th. That was 2 days before I jumped on a plane to go to Europe for Easter to visit a nephew who was over teaching on a Fulbright scholarship. So we filed a motion for extension saying that this came out after 5 months and we would like an extension to file objections. My proposed opposition replied within, we filed a memorandum of contract within 3 days. In the court, 2 days later, without waiting for the 14 days under Local Rule 7.1, or allowing us to file a reply to explain why I couldn't get it done in the 2 days before I left for vacation. And the court went ahead and ruled, without waiting for the 14 days under Local Rule 7.1, or granting us, or allowing us to file a reply to explain what I was doing in the 2 days before I left on vacation. Because it came out on the 26th, I don't know what time on the 26th we saw it, but I had 1 day in the office, the 27th, the 28th, I jumped on a plane, so we asked for an extension. And the court said I didn't explain enough about why I couldn't take care of the objections in the day and a half or 2 days that I had, before I got on the plane, and didn't allow me to file a reply. We think that's just plain error to do that in an abuse of the court's discretion. And I'll stop my argument there.
Thank you. We'll have the remaining time for vote.
May it please the court, my name is Glenn Alge. I am representing the Huntington National Bank in this matter and in the underlying proceedings. I know my time's limited, so I'll try to be as succinct as possible. Procedural history of this case is, I believe, important, simply because of the timeline that it creates. So I'd like to briefly discuss how we got where we are today. As counsel indicated, the complaint that was originally filed was filed by Mr. Bromer. It was filed by Pro Se. I understand any lack of sophistication with respect to that complaint. I have no issue with them coming in and amending the complaint. But I do want to point out that by the time Philip Bromer filed a complaint, it was January 12th of 2021. The monies that they are talking about that were in that account was approximately $6,000, and those monies had been taken out in September of 2018, within 60 days of the death of Joanne Bromer, but before the death of Cindy Wyman. And that's significant because nowhere does the appellant ever address why Huntington was supposed to automatically say, no, Cindy Wyman, you cannot have those funds. She was the only living member remaining for that account for that a month and a half period. And Huntington could not possibly cut off her rights. And quite frankly, there was never a request. As the magistrate correctly found, there was never any notice provided to Huntington National Bank for years until after Joanne Bromer died.
Well, counsel, let's just back up a little bit if you don't care. So whenever she died, you're saying nobody notified the bank and you didn't know?
That's correct.
Okay, and how do we know that? Is that via?
Mr. Esikoff had testified that in his deposition.
Okay, and that was submitted as evidence for the summary judgment motion?
That was not. It was a matter of the record, but I did not argue it.
Okay, all right. What did you provide to the court to demonstrate to the court that you were entitled to summary judgment then on that issue?
Your Honor, quite frankly, I did not submit an affidavit, and I understand that. However, that's the important part of one of the next amended complaints, and that is when they assert, I believe it was actually the third amended complaint, is when they finally asserted claims against Huntington National Bank, and those were asserted in May of 2022. That timeline is critical because in May of 2022, you're almost 4 years after these funds have already been exhausted. And
You're saying that there should have been summary judgment on another ground, or there could have been, that statute of limitations?
no, what I'm saying is they have said, they based their claim under Civil Rule 10. This is the document that they attached to their complaint. So my assertion, my suggestion to the court is, this document is not only not disputed by Huntington, it is by definition the document upon which they rely to support their claims. That's critically important because that document, they could say I should have had an affidavit to authenticate it. It was never disputed. No one's ever disputed that this is the statement for the account, that this activity took place on the account, and it was submitted pursuant to Rule 10 that they were relying upon. So I believe the document's already properly authenticated by virtue of their reliance on it pursuant to Rule 10.
And you would say the only factual dispute is one that doesn't matter, whether it's a joint account or a joint account with a survivor, and the results are the same either.
The result is the same. How can he conclude that a bank is supposed to immediately, number one, the appellant seems to assume that the minute somebody dies, the bank is aware of that fact. That's not the case.
Is there a jurisdictional issue here as well? Because the estate would be the one making the claim on the account?
The estate of Joanne Bromer,
Right.
well, they joined late to the party, but again, and that's what I wanted to mention on the complaints. On the first two complaints that were filed, the estate of Joanne Bromer was not involved in either one of them. And by the time that the estate of Joanne Bromer was in the third amendment complaint, they still never addressed, well, what about the other living member? The case law I contend that he is relying upon is all become meaningless because 110907 is what's often called the bank protection statute. And quite frankly, this statute was likely, I would submit, was adopted because the banks can't possibly make these determinations. When there's two names on an account, the bank cannot immediately, instantaneously say, okay, you put this amount in, so this is your money. You put this money in, so that is your money. This is all one bucket. And as long as there's somebody who is living and able to take that out, then the bank cannot refuse that.
So you're saying that even, and as I understand it right now, there's no evidence in front of the court below either way that the bank received notice of death, okay? Now, let's say the bank did receive notice of death. You're still saying that you were under no obligation to freeze that account or anything, that you still should have given the money to whoever else was on the account?
But Your Honor, had there been notice, then I contend there would be an issue. But the trial court found that there was no notice.
But how did the trial court find that, is what I'm trying to say? What evidence did it use?
I would guess the lack of the admissions of the appellants.
I guess my question is, that there's a lot of, if you're talking about a state filing an action, and you're talking about an open estate, you can talk about probate court.
Oh, I mean, that's correct.
So why would the judge even have jurisdiction to decide a summary judgment motion in this case? If really the proper party and the proper jurisdiction is probate court?
Well, Your Honor, I believe that they can because there's never been an allegation or proof that notice was provided to the bank. And as far as I can tell, that matter's been admitted. I do also want to bring out just some of the other claims that were asserted because I believe the counsel is asking for those, stating that there was insufficient evidence to get rid of those claims as well. That would be the alleged duty to pay real estate taxes. The appellants came back many years after the death of Joanne Bromer, and they took the position that my client had the obligation to pay the real estate taxes on the subject property. And in that case, the court really, again, based upon Rule 10, said, well, where's your document that says they have an obligation to pay the real estate taxes? There's no common law obligation, and they could not produce any such documentation. I glean from their pleadings that they're asking us to prove that we did not have an obligation to pay the real estate taxes. And I think the magistrate correctly found that, wait a minute, if you had an agreement, why would you, why is that not attached? And they didn't have one. So the court, I believe, correctly concluded that there was never any evidence of Huntington paying the taxes, and that is undisputed by the appellants, and that therefore they could not create that obligation out of thin air. The other issue that they raised was they wanted Huntington to foreclose on the property. Presumably they wanted that for litigation purposes. So in this complaint, they said that you either foreclose now, or we ask the court to preclude you from ever foreclosing and naming these parties down the road. And the magistrate correctly concluded that it's simply not any kind of relief that court can grant. So I believe those claims were both correctly denied, and that and quite frankly, I think all of the claims were appropriately denied. The record's not perfect. I'm not going to contend that it was. This was all coming about at the beginning of COVID. Things were a little crazy, so it did create some logistical difficulty. But there is sufficient evidence in the record, based upon their own attachments, that these funds were gone well before Huntington would ever have had an opportunity to stop that. I know I'm running out of time, and I don't want to impinge upon my co-appellee's time, so I will thank you for your time and your due consideration.
Good morning, Your Honors. May it please the Court, David Perdue for appellees, Dean Michelle Wyman. Your Honors, we urge this Court to affirm the trial court's decision which denied all of the Bromer's claims, only after a full trial on the merits. We ask you to affirm that trial court's decision for two main reasons. First, and most importantly, there's no transcript. There's no transcript before this Court to ascertain what errors, if any, may have taken place. This Court, the law is obviously clear that there is a presumption of regularity, and we rely heavily upon that. I think this Court does as well. The second main reason to affirm trial court's decision is with respect to the only argument brought up with respect to the Wymans is the failure to timely object to the magistrate's decision. As seasoned practitioners, we all know that there are certain things that are jurisdictional, that are almost immutable. A 30-day notice of appeal. You have 30 days to file a notice of appeal. You have 14 days to object to the magistrate's decision. There are certain things like that built into Ohio law that we all know and rely upon. While I don't think it was convenient for opposing counsel to have to object to the magistrate's decision 2 or 3 days before he left for vacation, the local rule was pretty clear that if you want extra time, there's got to be a practical impossibility of compliance. I don't know exactly how it's practically impossible, but I'm sure this Court is aware of circumstances where counsel or the parties or a court reporter error or something that makes it a practical impossibility. But I'm pretty confident that having to take a vacation for part, not all, but for part of that 14-day period is not a practical possibility. I don't think this Court wants to create that kind of precedent.
Well, counsel, it's all an abuse of discretion, right?
And it's abuse of discretion standard, even more important.
Okay.
Yes.
So, in regard to the amount of time, you compared it to a notice of appeal, but there's no law or anything that allows you to get an extension to file a notice of appeal, whereas with objections, you can get an extension if the court allows it.
You can ask for it.
Okay.
You could ask.
So he did ask for it.
Yes.
And the only evidence we have before us now is that everybody agrees it was only a 2-day period that he had to respond before he left.
Yeah, I thought it was a 3-day, but okay, 2 or 3 day. I do agree with that. And that is not an affidavit, they're local required an affidavit, a sworn statement. Yeah. Again, I don't think that the trial court's denial to grant it extra time constitutes an abuse of discretion. I would hope that this court wants to give the discretion to the trial courts to decide the matters before it.
I guess I'm just trying to figure out what the abuse of discretion, I mean, there's so many different ways of looking at it, but one is just being unreasonable. Isn't it a little unreasonable to expect somebody to respond to something within 2 days, whenever they're usually given, where they are entitled to 14 days?
I thought of that, and my response is this. The substance and the objection to a magistrate's decision is not a brief before the court. It is, we object, and we ask for time to supplement the record with the transcript which they didn't order, but you don't know that because there's no transcript. But they never ordered the transcript. You don't know that. I'm telling you that. He was there, I was there, they didn't order it. So the point is, if you have the time, whether it's 1 day, 2 days, or 3 days, to file a motion for extension of time within which to object, you have the same ability to just object. If you're unsure,
But if you don't make those objections well enough, then you have a problem on appeal,
it is my
especially
understanding.
when it's a very long trial.
I get that. Is my understanding that we have the right to supplement those with the transcript?
But the right to supplement would be whether the judge allows you to supplement, which would then turn on whether she abused her discretion in allowing supplementation.
Understand, but you have to ask for the transcript in the first place, which was never asked for at the trial court level. I was there, I was present. I don't think there was ever an intention to object, regardless of win or loss, in my experience, my opinion from being there. I see that I'm out of time.
You've been asked our question, so please briefly conclude if you would.
Yeah, essentially, we are asking the court to look at the case law and look at the local rule, and while there may seem an unfairness or possible unreasonableness, the local rule states a practical impossibility. And I don't think what was stated before the court without an affidavit was a practical impossibility. So we urge the court to affirm the trial court's decision in full. Thank you.
Judge Lindsay, I'd like to answer a question that you asked my opponent. You asked whether this court had jurisdiction. They do. Because the issue is whether the assets were in the estate or whether they're in the trust that the parents established. So we brought a declaratory judgment action to determine whether this should appropriately be estate assets, the personal property, or should be property of the parents' trust. That's why it was brought in this court and not in probate court as a declaratory judgment action, which I don't believe probate court can actually render declaratory judgments. I may be wrong on that, and I don't want to be stumped. But I do think it is appropriate. You've got to bring the trust in and determine which one actually had the claim to the personal property. And that's why it was brought in this particular court. I remind the court that there were two amended complaints filed by. One is the original one I filed when it came into the case. The second one I filed joined the Huntington, but not on the bank account issue. It was on the issue of the real estate, because the note also had a due on death clause that comes to effect. And what I tried to argue is, if the Huntington continues to operate as if it does not have notice that the decedent is dead, they still carry the account in her name. They still send monthly statements to her, even though in that deposition that we took after the after matters were all submitted to the magistrate, they admitted they had gotten written copies of the notice of death. They had gotten copies of the notice of death shortly after she died. They went to the bank and informed them. They've admitted they've received, and they've asked for it again, and they admitted that in their deposition. Was that in our complaint? No, it wasn't, because we hadn't taken that deposition at that point. And in fact, that deposition wasn't even in the record by the time that they filed their motion for summary judgment. There's no evidence about them not being on notice. In fact, that's been our argument all along. They know she's deceased, and to this day, they still continue to carry the account in the decedent's name. And what's that mean? And what I asked for was not that they couldn't foreclose on it, but that they couldn't name the estate and the decedent in any subsequent foreclosure case, or the heirs of the estate. Because they made it clear that if in fact they were going to let stand that this property was now in the name of Mr. Wyman, they couldn't continue to carry the financing of the account in the name of the decedent as if she was not dead. To this day, the Huntington Bank refuses to acknowledge that the decedent is dead. And why? Because the due on sale clause comes on point. And that was the original reason we brought them. In their motion for summary judgment, their alternative motion for summary judgment, they didn't even address the issues with regard to the real estate. They didn't even raise them in that motion. They only brought up the issues of the account. And that's what my point is. That this is not raised, they did not support it, there was no evidence, but they got judgment on things they didn't even move for summary judgment on. And so that's my point with regard to the Huntington. With regard to the other matter, yes, with regard to the Wymans, there is a transcript in the record, by the way. It was ordered by the magistrate to write her opinion. So it's in the record. What counsel's talking about is we didn't order a transcript, is we were given the opportunity to order the transcript to write our closing arguments. In view of the $4,000 figure that we were quoted to get the transcript, neither party used the transcript to file our, to write our closing arguments. That's what he's talking about. We didn't order it.
Is the record, the magistrate order included, or the transcript included in the record?
Yes, I checked. This is, they come up here on appeal. The transcript is there of the trial that took place in October. We had not obtained a copy of it yet. As I said, it came in on the 26th, my next to the last day, the 26th, the next to the last day. I got, was doing, as you know, some of all of you had the experience of practicing law a little bit or working in office. Before you leave for office, you got a bunch of things you've got to clear out. And did I get on and order the transcript? No, I left it with my office and said, hey, can you guys take care of this, file a motion for it.
Counsel, I know your time is up. Let me ask you the point of opposing counsel. Why didn't you simply object and ask for time to supplement your objection?
I didn't have time to do that before I got on the plane. I just did. I was packed with everything.
How much more time would that have taken than to ask for an extension? To ask for an extension of time to object, to say, I'm objecting, I want time extended to file my grievance.
It was filed, I didn't do it myself. My partner filed it and signed my name to it after I was out of the country.
Okay.
And so I didn't do it, and that's the reason.
That's a fair answer. Thank you.
Thank you.
And thank all of you today for your presentations. The court will take the matter under advisement and issue a decision in due course. When that decision is reached, it will be mailed to you by the clerk of courts. It's also be available on the Ohio Supreme Court website. With that, the court is now adjourned and will be in session on Thursday, September 12th.